After 5 years of having clear guidance on how rest and meal breaks must be allocated, employers are still getting it wrong. In this episode, I do a deep dive into where rest and meal breaks fall by the wayside and how you can ensure that your business always stays compliant. Hi everyone, welcome back to Law Lenz. My name is Sanam and thank you so much for tuning in today. I am back and I am here with a much better voice than I was last week, so hopefully this is sounding a lot better to you all. But thank you for bearing with me because last week was definitely a saucy one and I will list the information in the description if you did want to check it out. As for today, we know it's very commonly known that people need to take rest and meal breaks, they need to take time off because it's not only important for their physical health, but also for their mental well-being, right? It's all about managing fatigue and making sure that employees have time to attend to their personal matters as well. We know everything operates in business hours. Sometimes you need to call IRT, sometimes you need to call the bank. Unfortunately, it's hard to do that outside of business hours. So these are the reasons why you have these rest and meal breaks. Now, on top of that, the added layer is that it's also a health and safety related matter as well. Because if you look at the health and safety at work legislation, and that's going to go through its own revamp. But if we look at the basics of the legislation, then we can see in there that generally a hazard is something that can come up because of mental fatigue or physical fatigue. And by providing rest and meal breaks, you're mitigating those particular risks. And it allows employers to take practical steps to ensure that there isn't fatigue happening in the workplace. With all of that and that long-winded explanation of why it's important to have breaks, it's crazy to see how many employers are getting it wrong or how many employees are asking questions around it. Now, you may be thinking, Sanam, how do you know people are asking these questions? I went onto Reddit, of course, and I did a bit of a deep dive on there to look at when rest and meal breaks have come up in threads and conversations, and what I saw was alarming. You are not going to believe this, but just in the year alone, I saw over 25 questions related to breaks. And from that, a few of them were only from a couple of weeks ago. Isn't that insane? An overwhelming majority of those questions were about employers not allowing the employee to take breaks, or they were asking the employee to just work through the allocated break times that they were meant to be taking. This begs the question of why are employers getting this so wrong? What is happening in the workplace? And I personally think I know what it boils down to, and I'll get into all of it, but I won't leave you hanging. I think it boils down to the fact that employers think the law is very rigid. It says that you need to take your breaks between this time, and that's what it's got to be. And it doesn't fit in with the practicalities of my business. But you'll be surprised because there is a lot of leeway there. The problem that comes up, and what I've personally seen as well, and I'll get into some anecdotal cases that I've dealt with, which are about rest and meal breaks. But when I see those cases, it's usually because the rest and meal breaks haven't been clearly defined anywhere. Not in the employment agreement, not in a rostering sheet or a timesheet, or even a clock in and clock out card, anything like that. There hasn't been that record there, and that's where the employee can say, look, I haven't actually been provided with my breaks. But before we get into all of that, I just wanted to say thank you so much to everyone that has been following the podcast, and I can see the following going up. So please, if you're liking these episodes, then absolutely hit that follow button. Make sure you jump over onto LinkedIn and follow me over there because I give you key employment law insights and more over on LinkedIn. Now, getting into it, we want to talk about firstly, what are rest and meal breaks? I don't want to hammer into this too much. I want to keep it very brief because I will put the information down below. What I wanted to get into mostly is where employers get their rest and meal breaks wrong and how you can actually make sure that you're doing things correctly. The first thing is, what are rest and meal breaks? And this is all detailed under Part 6D of the Employment Relations Act. Employment Relations Act is your go-to, and what it details is that there are entitlements that an employee gets. It doesn't doesn't matter if they're a casual employee, a permanent employee, they all get the same entitlements. But basically, the entitlements are set based on the duration of the employee's work period. So whatever their work period is, that will dictate and determine the minimum entitlements to rest and meal breaks that they get. Let me give you a couple of examples. So for example, if an employee worked between 2 to 4 hours, so up to 4 hours, then they would get one 10-minute paid rest break. If they worked between 4 hours to a maximum of 6 hours, then they would get one 10-minute paid rest break and they would get one 30-minute meal break. Now, with the meal breaks, they are generally unpaid, so keep that in mind. A meal break, generally unpaid, and a rest break will always be paid. You cannot opt out of that. Now, the last one I wanted to talk about, which a lot of people will fall into this bracket, and I know I'm excluding a lot of people, but like I said, it's all in the description, is the 6 to 8 hour shift workers. So if you work between 6 to a maximum of 8 hours, then you get two 10-minute paid rest breaks and you get one 30-minute meal break, which is usually unpaid, but some employers are a lot more generous and they may give you a paid break for that. So that's usually how it's split up. And as you can imagine, as you can see, it keeps extending out in terms of the hours that are tacked on. So if you go above 8 hours, then you'll get extra breaks, extra meal breaks, extra rest breaks as the hours keep ticking up and up. And that's to allow you for the time to be able to actually minimize fatigue, mitigate any of that fatigue risk, and make sure that you can actually do the shift adequately and also safely. When it comes to the timing of the breaks, this is where I believe a lot of employers feel like they need to opt out of breaks because it just doesn't fit in with their business. Now, general rule of thumb under section 69ZE, I know we're getting into a lot of letters in this one. I was looking at it going, there's a ZED, ZEE, it's just a lot. Anyways, so getting into the particular section, it says here very clearly that employers and employees should agree upon the time that the break is meant to be taken. If there isn't any agreement, then that's where, by default, you follow the piece of legislation. And it needs to be approximately in the middle of the work period when you're looking at meal breaks, for example, and then on either side of the meal break is those rest breaks as well. And you need to make sure that you provide these within the frame of the law if you don't have an agreement. Ideally, you should follow that structure. The reason why I say that is because it's very common for employees to say, I'll just work through my break and then I'll take it at the end of the day. The whole purpose of the legislation is to stop that from happening. So you need to stick as closely to those parameters as possible, but that's not to say that you can't reach agreement with the employee in good faith. Now, if you're part of a sector that has an exemption, it's a lot different. I'm not going to hammer into this too much, and it's because it is an exemption. For a lot of industries, this will not apply. We're talking about national security and essential services like people in the medical profession. Those particular employees, they may need to work throughout their breaks, or they may not get their breaks within the correct times. And if that's the case, then there needs to be alternative arrangements for breaks that are agreed upon. Or if there's no agreement, then you need to make sure that you go down the compensatory route. So you're providing the employee some sort of compensation to cover them off for the fact that they never took a break. That was everything in relation to what the rest and meal breaks are, what it actually means. So you know that those rest breaks are all about that 10-minute paid break. The meal break is usually a 30-minute unpaid break, but you can pay an employee if you want to, but there's no legal requirement to do that. And they need to be provided those specific breaks within the designated times as per the law, or if it's been agreed with the employee separately. Now, I'm going to get into all of the areas where the employer can go wrong, because I thought it would be great to provide examples and to talk about where an employer can fix this quickly and make sure that they stay and they remain compliant. So the first one is to clearly detail how rest and meal breaks are going to be taken. You would be so surprised to know that there are a lot of employment agreements out there that do not detail anything about rest and meal breaks, or if they have anything detailed in there, then it is actually quite ambiguous. So it's really important to have something very clearly laid out in the contract, whether it's referring to the Employment Relations Act or it actually details exactly how the rest and meal breaks need to be taken. I know some people like to put in the exact way the rest and meal breaks are to be taken because their business actually allows for the employee to take their rest and meal break in accordance with the timeframes provided by the legislation. For other employers, though, it is really important to make sure that you clearly lay out in the agreement that there is going to be some agreement that's going to happen there, even though it is something that the law allows, but it's important to clearly lay that out. And I'll tell you why, because I'm going to go through a few cases here, and I'll link all of these cases in the description if you wanted to have a read. But the first one was around a sushi restaurant where the employee claimed that they did not take any rest and meal breaks, and there was no record of them taking rest and meal breaks. It is really important for the employer to show that they allowed the employee to take the break. What was really critical in this case was that the employment agreement needed to make sure that it clearly laid out that the rest and meal breaks needed to be taken either in a particular way or how the employer would come to a conclusion on how that rest and meal break would be taken, because there was no other record in the workplace around rest and meal breaks. And if you remember to the beginning of this episode when I said it's really important to have timesheets, time recording, or something in place to show that this employee has taken those breaks, it is truly critical. I personally had a case that came up. It was a migrant worker exploitation case. I represented the employer. The employer was very adamant on the fact that the employee worked long shifts, but they absolutely took their breaks. And a lot of times the employee wouldn't leave the premises, not because they weren't allowed to, but because their family were all overseas. So they didn't actually have a home that they really wanted to go to. So they would stay on premises. And there was a room upstairs where there would be facilities where they could rest, be on their phone, watch some TV, and hang out. Now, in that particular case, it never made it to the authority. It settled prior to actually going into an investigations meeting. But what we did see in that case was that the employer never had the employee clock in, clock out for their shifts. And if they were doing such extensive hours, they might have been working 10 hours, 12 hours, 13 hours a day, and they needed to take all of those rest and meal breaks. There was nothing backing the employer to say that, yes, this employee took their rest and meal breaks. All they had was their pay slips and the payroll system, but that's just not enough. So for these reasons, in that sushi case, you can see that the Employment Relations Authority said that the employer unjustifiably disadvantaged this particular employee. And similarly, in this case, it was very hard for the employer to prove that the employee had actually taken their breaks. If it went to investigations meeting, maybe we could have used eyewitness accounts, but it just didn't make it there and it wasn't tested. So what can you get out of this? It needs to be clearly defined in your agreements that rest and meal breaks are set out as per the Employment Relations Act. And also, if the breaks need to be agreed upon mutually between the employer and employee, then how do you go about that? You don't need to feed all of that into the agreement. Let's say that you just have a line in there that the rest and meal breaks will be agreed upon based on a mutual agreement between the employer and employee, which is as per the legislation. But let's say that you want to get into a lot more detail. Then why not have a policy in place? If you have an employee handbook, throw it into the employee handbook. There's no harm in having that in a policy, in a handbook, somewhere that details this information. And another case that came up was about an employee that had this exact same situation where the provision of rest and meal breaks were completely silent when it came to the agreement. There was information in there around rest and meal breaks, but there was no workplace policy on the implementation of rest and meal breaks. So there has to be something in there that you have in writing, which the employee is fully aware of and fully understands that they need to take the rest and meal breaks in this particular way. So for example, having a policy that says the employee will take their rest and meal break at this time or this time, depending on their hours. Or having something in there that says that the employee will need to make sure that they clock in on an app or that they do something to note that rest and meal break. And that the rest and meal break, if it hasn't been taken, then it needs to be flagged and raised with the manager. All of that needs to be very clearly detailed, because then it provides no grounds for the employee to say that they were not given a rest and meal break, that they were told to continue working, because you're giving them in writing very clearly what is expected of the business. What can come up quite often is that an employer will say, push through and work through your breaks. It should not be the directive of the employer to say you need to continue working through your breaks, especially if this becomes habitual and we're talking about this happening day in and day out. Ideally, if you've got your policy in check and you've got your employment agreement in check and everything that you've got is all in order, then ideally what you can do as an employer, and this is only occasional, please know this. Let's say you're in a busy cafe, it's peak time, it's really hard for them to take a 12:30 break, and that's smack dab in the middle of their shift, and they need to be taking that meal break. Then it's absolutely fine for you to follow your policies, your employment agreement, and speak to the employee and reach an agreement and make it very clear that agreement has been reached about them taking a break maybe slightly later or maybe slightly before. Now, I say that and you might be thinking, okay, Sanam, how do we fairly and reasonably do this when we're in the thick of business and we're trying to get stuff done? If that's the case, then it's really important that you set the parameters up beforehand. So I'll get into one of the cases that I saw. Basically, the employer said to the employee, between this time and this time, we ask, because it's busy, for you to take your bathroom breaks or your rest breaks prior to those times. It's not saying that you absolutely cannot go to the bathroom, you cannot take any rest breaks, you cannot do this. It's to say that we would prefer for you to take it prior or after these particular times because we are going to be busy during this time. Usually, as an employer and as a business owner, you can see where there are fluctuations in the business based on the timing of the day. A lot of times, employers just do not take that extra step to navigate their employees around the busy periods during work and the quiet periods during work. And what ends up happening there is that the employer turns around and just says, work through, or the employee thinks that they need to be working through. But you should set clear expectations. Do that and there won't be any worries. Trust me. When it comes to going to the bathroom, this is a very common issue that I can see, and I've dealt with cases as well where employees are clearly on their phones sitting on the toilet and they're not coming back. They've done their rest breaks, they've done their meal breaks, and their employer's thinking, why are they going to the toilet 5 times a day? It seems that many employees in these Reddit threads have also been querying whether they're allowed to be able to go to the bathroom multiple times in a day. So like I said, with these ones, it's exactly the same as that previous case that I was talking about, where the employee would go to the bathroom and said that they weren't able and they were barred from going to the bathroom. What allowed the employer to be successful when it came to that specific point was that the employer said they would rather the employees try to take their breaks before and after the busy periods, but they never said that you can absolutely not go. You need to make sure that you're here all the time. They just gave an expectation, which allowed the employer to be successful in that particular situation. Keep that in mind. When it comes to bathroom breaks, if you're seeing that it's becoming excessive, then it is really important to speak to the employee. One, it could be a health and well-being thing. So you really need to speak to the employee, do an informal kind of meeting, just to catch up. Don't make it formal, don't make it onerous, just to say, hey, how are you going? We've noticed this, we just want to see what's going on. Is there anything that you wanted to chat about? And I know it can be a bit of an awkward conversation, so know what you think is the best to do in that circumstance and tread carefully and then go into it. Other than that, missed breaks seems to be the other most common thing that comes up, and missed breaks time and time again are because of unforeseen situations that come up in the workplace. It's unforeseeable. Sometimes employees may need to work through. Now, like I said, it can't be habitual. Don't make this a thing. It can't come up every single time. It can't come up every single day, but you need to make sure that you are providing the employee that time that has been lost. For example, if they miss a 10-minute rest break, then you need to let them wrap up 10 minutes earlier, or maybe they start 10 minutes later the next day. It's really important to do that because at the end of the day, you won't be providing them those rest and meal breaks if you're not actually giving them anything. Now, in terms of where this can go wrong and how this comes up in terms of a personal grievance, well, it's raised usually as an unjustified disadvantage personal grievance. This type of disadvantage is around the fact that the employee has been given unfavorable circumstances or unfavorable conditions compared to what their minimum entitlements should be. In one instance, it could be that maybe they feel targeted and disadvantaged compared to everyone else. But in most cases, when it comes to rest and meal breaks, in this particular scenario, it's usually to do with the fact that they've been disadvantaged compared to the minimum entitlements that are actually provided under the law. With an unjustified disadvantage claim, we can see that usually the bracket that they're falling in is that first band of compensation. I've got a whole episode dedicated to that, and I will definitely link that. highly recommend that you check that out because it goes into the details around where a case may fall. And what we usually see now is that if it's an unjustified disadvantage case, let's say it hasn't caused much mental harm, mental stress, or anything along those lines, then there's a chance that this will fall into band 1, which has a maximum of $12,000 in compensation that needs to be paid to the employee. This is just for the disadvantage claim, and usually for a disadvantage claim, we would see less. But like I said, it depends on how much mental harm or how much underlying health effects this has caused. So just keep that in mind. If not going to the bathroom or not being able to take breaks has exacerbated an underlying medical condition, then all of those things will play into this and it could increase that compensation amount. Now, when you get up to the stage where you might be in front of an authority member, and I hope you never have to be, I really do, but let's say that scenario comes up for someone, then it is really important to understand what you may be liable to pay. And generally with these penalties, you're looking at about $20,000 per breach of a particular section of the Act. And in this case, a lot of times it would be that breach of Section 69ZD. And in one of the cases that I saw, it was actually quite interesting. And I wanted to bring this up because I know a lot of employers, and I say this, and I truly believe this with a passion, a majority of employers are not sitting there going, I want to stick it to this employee, or I hate them, and I'm not going to give them any rest and meal breaks, or I'm not going to do X, Y, and Z. That's usually not the case. Usually, an employer just does not understand the obligations, and when you're running your business, you do not have the time to go and seek and understand employment law because it's not easy to grasp. So with that said, I wanted to bring this up because the penalties, yes, they are dire, but if you've genuinely made a mistake here and you're facing an authority member, then please know that there have been cases that have gone to the authority, and one of them is around the fact that the Employment Relations Authority member looked at the scenario, looked at what the employer was doing and said, actually, I can see here that the employer is genuinely doing things to make sure that they are complying with New Zealand law. They have not only gone out and gotten a New Zealand employment advisor and made sure that they follow all the recommendations by the authority, and they also make sure that they've gone out and they've tried to rectify any of the mistakes that they have made so far. And because of that, the authority member decided not to exercise their discretion to award a penalty. So there is a chance in these cases where you do not get penalized for what's been done. That's not to say that they didn't pay compensation, lost wages, and all of those other remedies. What we know time and time again from all of these cases is that saying that you did not know or that you did not understand is just not good enough. Well, that's it for me, everyone. I hope that this was a really informative episode and it gave you a lot of details around what you need to understand in terms of your compliance requirements and where employers generally go wrong. And I truly believe it's because they do not have the systems and processes in place from the employment agreement all the way to the workplace policies, all the way through to having a system where you can clearly see where the employee has taken their break, when they've taken it, and during which time and which periods. If you've got all of that, then you are fully covered, my friend. Now, if you've been enjoying these episodes, then like I said, make sure you follow the podcast. Thank you so much to everyone that has been reaching out. It has been lovely hearing from all of you, and absolutely keep it coming. I love to meet the community that we're creating here, and I believe that one day at a time, we're going to get employment law not just done, but done right. Thank you so much, everyone. I hope you have a lovely day, night, evening, morning, whatever it may be. And guess what? I'll catch you in the next one, everyone.